आधे बाउल दही में 4 चम्मच MDH चटनी पुदीना मसाला डाला, स्टर करो, पुदीना चटनी तैयार। MDH चटनी पुदीना मसाला।
From the Republic Media Network headquarters, it's time for Arnab Goswami on the debate. Arnab Goswami on the debate.
Time now for the nation's sharpest opinion. I want to begin by thanking all the viewers of Republic, the millions and millions of people who have responded in a huge manner to our campaign to save the Aravallis. Unfortunately to them, I would say that nowadays, if you question government policy in public interest and you remind the government that it should be the government which should be thinking about public interest and not corporate interest. That it should be the government which must think about the people and not for corporates. You are told that it's a political conspiracy. These are people who are either blinded by arrogance or motivated by vested or personal interest. Republic, as a media network, an independent media network, we do our job, we couldn't care less. What I do know is that our position on Aravallis has resonated with you, the people of India. And I would once again like to ask a simple and fundamental question tonight. A 2 billion year old mountain range is redefined 3 days before a Chief Justice of India is about to retire. I'm not drawing any link, but I'm just stating a fact. Now, my first question tonight is on the principle of why a judgment of the Supreme Court of India, no less, does not need to pay heed either to domain experts or to the Amicus curiae, defined as the friends of the court. Ladies and gentlemen, the job of the Supreme Court of India is not to consider all points of view and then agree with the government. The Supreme Court of India has the right to take that stance. Technically, nobody can question it. But there is something called logic, sensitivity, and precedent. Ladies and gentlemen, the Supreme Court went against the Amicus curiae, the friend of the court. And I want to ask them, because in para 30 of the judgment, it is clear that the Amicus curiae had stated in his submission that he was not for this committee's definition, that the committee's definition of this 100 meters or less mining can happen would endanger the environment and the ecology of the mountain range. I have the quotes, I have the documents, it's all on paper, ladies and gentlemen. And the nation wants to know tonight, why did the courts not pay heed to their own legal friend appointed by them? Further, in para 28 of the judgment states that Senior Advocate K. Parameshwar, the Amicus curiae, opposed the new definition, this 100-meter bizarre, crazy rule. He argued that the earlier FSI criteria better preserve the ecological integrity of the Aravalli ranges. Why was the view of the friend of the court not taken into account? Now, viewers, these are questions the government should be asking. I hope the government knows the difference between the Ministry of Environment and the Ministry of Mining. It is not for the Ministry of Environment to put out what I found today to be a weak and unconvincing defense by Bhupendra Yadav, the Environment Minister, who I think is himself not sure of his own arguments. Absolutely not sure. The question Mr. Bhupendra Yadav should answer, why did the government as well as the Supreme Court go against the forest report? The facts are with me. Not only did the courts go against the Amicus curiae, They also went against the Forest Survey of India. As stated in para 27, the Forest Survey of India had defined the Aravallis in 2010 as, and I quote technically, under 1 slope greater than 3 degrees, 2 foothill buffer equal 100 meters, and 3 the interhill distance or valley width 500 meters, and 4 the area enclosed by the above defined hills from all sides. Now this is information given by domain experts, by people who know, by subject matter experts, people who know enough about the subject of ecology and forests and mountains and geology to be able to provide expert opinion to the government, to the Supreme Court. Why would the courts take a contrarian view to both the Amicus curiae as well as the forest report and give a judgment 3 days before, ladies and gentlemen, the Chief Justice of India is to retire? What is the tearing hurry to redefine the Aravallis? And this is logic, ladies and gentlemen. This is logic. For anyone to come out and say right now that we have the right to do something. I want to tell the courts, I want to tell the government, just because you have the right to do something does not mean you end up doing something, regardless of political or public backlash, which goes against national interest. I'd like to tell the government once again that in national interest, in public interest, revisit your own positions. Do not use this trapdoor logic that we managed to get the government to agree with our positions. And hence, we'll shoot off the shoulders of the Supreme Court to whatever we want. To the Supreme Court, I would say that empathy and conscience are extremely important. This whole attempt to create this central illusion that we will not allow mining doesn't make sense. Ladies and gentlemen, the new definition of the Aravallis is a de facto mining enabler. A de facto mining enabler. This is going to destroy the Aravallis. It's going to destroy the ecology forever in a manner the government and future governments will not be able to change. This whole idea of sustainable mining in its definition is an oxymoronic statement. I want to ask the government, who benefits from what you are trying to do? Who benefits? I want to ask the central government, which is very sensitive to criticism, who benefits? Do the politicians not realize that Republic has accessed the 2,334-page additional affidavit filed on behalf of the Ministry of Environment, Forest and Climate Change to the Supreme Court of India, purportedly in compliance with its order dated 9th May 2024? A close reading of this affidavit exposes a direct contradiction between the government's public claim of protecting the Aravalli range and the policy intent recorded in its own sworn admissions. Why is the government and the Supreme Court so keen for mining? And what about the principle of precaution? There is a legal principle of precaution, ladies and gentlemen, wherein matters of law and matters of law connected to environment, you generally steer and move towards precaution. Don't do anything today which is going to be irreversible for the ecology and environment in the future. In this case, all of the above have happened. And the people of India have a right to ask the questions that we are putting forth on their behalf tonight. And let me tell the government, the people of India are watching. A one-day, two-day rehearsed and unconvincing defense is not going to be the end of this public battle by the people of India to reclaim their rights in matters of ecology. Because it matters to the people. And therefore, and only therefore, it matters for Republic. Let's debate.
This was the scene in Udaipur today, demanding protection for the oldest range, the Aravallis. Even as the government presented an unconvincing defense.
कई लोग कई तरह की बातें कह रहे हैं कुछ हमारे वरिष्ठ नेता लोग भी भ्रामक ट्वीट कर रहे हैं। सबसे पहले मैं क्लियर कर दूं, एनसीआर रीजन में माइनिंग अलाउ ही नहीं है। तो जब एनसीआर रीजन में माइनिंग ही अलाउ नहीं है तो उनका तथ्य ही झूठा है। दूसरा, ये डेफिनेशन आने के बाद भी इस निर्णय में ही ये कहा गया है कि अभी कोई नई माइनिंग लीज ही नहीं दी जाएगी।
The voices on the ground are louder than ever.
आप बताइए, देश का युवा सड़क पे उतर आया, क्या मांग है सरकार?
सरकार से यही मांग है कि अरावली को बचाना है। अगर अरावली नहीं रहेगी तो पानी कहां से आएगा? किसान कैसे जिंदा रहेगा? रेगिस्तान बनने से उसको कौन रोक?
And the stakes are higher. A 2,334-page affidavit has now revealed the government argued for mining strategic minerals in the Aravalli hills. Lead, zinc, silver, copper, minerals the government says are essential for India's cleaner energy transition. A shocking revelation that clashes with public assurances. The protection of Aravallis becomes even more important amidst rampant mining in the region.
Behind me are clear live visuals of mining activities going on broad daylight. All this mining activity is illegal and has been stopped. However, the villagers have been trying to protect their agricultural land and they have been trying to protect their grazing fields. To the left of me is a 200 feet deep mine. Villagers here have informed us that all the mining activity happens at night. They are using blastings, they are using dynamite, and no safety equipment is being used.
Similar is the scene in Rajasthan where Republic team found several instances of illegal mining. Will the government defend itself in the court? The streets are speaking louder. The Aravallis must be protected. No compromise, no delay. This battle for India's oldest mountain ranges has only just begun, and the nation is watching.
Ladies and gentlemen, joining us on this debate tonight, and I'm likely to be joined. In a few minutes, I'm happy to say that likely to be joined by the former, till recently, Chief Justice of India, Mr. Gavay. I requested him and he may be joining us at a bit. So that's going to be a very interesting conversation I will have with the former Chief Justice of India. Ladies and gentlemen, I want to begin by saying that I want to thank all the people of India for the incredible support that they have given Republic in this public campaign. Hasn't it been absolutely fantastic? Vimlendu, I think people have come together on this and we believe we can win this. Vimlendu, to start with, Vimlendu Jha, founder of Switch India. Vimlendu.
Yes. No, I think it's very important that this issue was raised by you and many others. In fact, of course, very rich on the part of the Environment Minister to come up after several days and almost, when you can't convince someone, confuse someone. And that's exactly what has happened. Suddenly he's realized that he was also referring to the hill height under the ground, because if you look at that document that was actually presented to the court, that was only talked about the ground level and 100 meters above. And suddenly he's also talking about the hill or Aravalli that's under the ground in that sense. Also for him to really say that this is not his decision, but the decision of the Supreme Court, versus if you look at all the submissions that were made in the Supreme Court in last decade and a half, or for that matter, for almost 3 decades, when the mining was banned, when these definitions were rejected, and it was this government and government alone that actually went with this proposal once again. And imagine, as you were talking about, and we've been talking about it for weeks now, that reality is that when mining was so-called illegal, we lost almost 1/4 of the Aravallis. And now, by this new definition, which is almost as if, today it's 100 meters, as if, a scientific technical understanding presented as per the convenience of the mining mafia and perhaps of the government, who perhaps have some interest, one would say, because otherwise, if the interest of people was paramount for the government, they would not have accepted this decision, whether it came from Gehlot or came from some other government. The reality is that is the same Supreme Court that had rejected this definition, the same Supreme Court that had completely 100% banned mining. And in whatever way, the fact that whatever the Environment Minister is saying right now, the fact that he's giving permission to mine in whatever degree or excuse that he's talking about, in the backdrop of a terrible air quality, in the backdrop of a climate crisis that the entire region is facing, in the backdrop of hundreds of people lost their lives because of heat stress and heat wave and the water scarcity. So therefore, rather than taking a progressive step to ban, to stop pollution and stop degradation of our ecology, here we have an environment minister and the entire machinery of the courts and the government actually going ahead and calling it sustainable mining.
First of all, let me say one thing tonight. To the Supreme Court, I would say take responsibility for your actions. Don't say we are agreeing with the government while rejecting the Amicus curiae, what they say, while rejecting what the forest experts say. And to the government, I would say that don't shoot off the shoulders of the courts, for God's sake, elements everyone on. Don't say we are only doing it as per the Supreme Court's guidelines. And to the people of India, I would say, please note that 3 days before CJI Gavay was to retire, he gave this judgment. I hope he joins me on the program tonight. Now, ladies and gentlemen, the government's explanation, people are asking me, what do you think about it? I would say it's pathetic. It does not cut any ice at all. This judgment has redefined the Aravallis, nothing changes that. What happened was that the government was trying to get this done through stealth. And this new definition is an enabler of mining. I want to ask the government, why is it so keen about mining?
Can I come in on?
No. Earlier on the court's own directions, viewers, the Forest Survey of India had given a far more ecological definition using specifics that experts use. All this was thrown out. The minister hides behind the court. The Honorable Union Minister hides behind the court while omitting a crucial fact that this is a MOE FCC drafted court-stamped mining-friendly definition that amputates most of the range, and then boasts that only a tiny fraction of the amputated limb will be mined. But it's been amputed. The amputation will happen. And then you'll say we'll only use a part of the amputated hand. It doesn't make any sense. People are angry, Sanju. Very angry tonight. And people are also well-informed. Very well-informed. And we are making them more well-informed. Now, Sanju.
Thank you, Arnab.
Now, Sanju, my question is coming now. My question is coming now. Please listen to me. You swear that only 1 or 2% is mineable and 90% is protected, but your ministry, your government authors the definition that erases over 90% of those lungs from the legal map, and then you ask the court to bless it. So the question that flows from your own documents, your own laws, your own history is this. If you truly believe that the Aravallis are essential to India's ecological survival, why did your ministry not fight to expand the definition and protections? Why did you instead design the very scalpel that cuts 90% of the range out of the body and then tells the country only 2% of the corpse will be mined? I have the entire additional affidavit filed by your ministry in the Supreme Court of India. It has been read. It has been read. And this is pro-mining because you want to do a lot of mining.
Arnab, you'll have to give me time to rebut.
Just one question. Listen to the question. You don't start a rebuttal without thinking of the question.
Oh, you've been making allegations. Come on. It's only fair that I get a chance to rebut.
The question is this, and here's the question to you. You're trying to rebrand the Aravallis as an underutilized mineral asset, framing the hills primarily in terms of extractable value and future revenue potential. Now, my question is, does equally necessary mean ecological protection is no longer overriding? One, point to any Supreme Court order where mining has been treated as equal to ecological preservation in the Aravallis. If ecology is foremost, as you say, why does the affidavit refuse to say that mining is subordinate? Is there any environmental or legal doctrine, and please pay attention to my question, don't come with your prepared and rehearsed answer,
Oh my God.
where exploitation is described as equally necessary to preservation?
You know, Arnab, I think you will allow me a rebuttal because I've known you to be courteous, and please don't second guess me. Sanju, you've come with a rehearsed answer. No, I will not come with a rehearsed answer, but I will speak the hard facts on your show, because this is an issue that concerns all of us, irrespective of our political ideologies, what have you. I think the biggest concern, and please don't interject me, Arnab, the biggest concern is this, that the new definition allows mining in all landforms below 100 meters of height. That is what I've heard various climate activists saying. And I say on your show with full responsibility, that is absolute balderdash, because all landforms enclosed within the lowest binding contour encircling hills of 100 meters or more, irrespective of individual height or slope, are excluded from mining leases. That's my rebuttal number one. My rebuttal number two, Arnab, very respectfully, is this, that the new definition, people say, has diluted, suspended, or overridden various existing statutes which actually conserve the environment. I again say that is balderdash. The new definition does not in any way dilute the Environment Protection Act of 1986, the Forest Conservation Act of 1980, the Wildlife Protection Act of 1972, or the EIA notification. My third and very important point is this. Aravalli/Aravali range/Aravali hills. The limited point is this covers a total expansive area of little over 1.44 lakh square kilometers, stretching from Gujarat right into the heart of Rajasthan and then into Delhi, and of course also parts of Telangana. The limited point is this, as Bhupender Yadav said, I don't want to reinforce what he said, but sometimes repetition is very important so that the facts sink in. He has said this on record. Only 0.19% of 1.44 lakh square kilometers will be available for mining. That means barely 273 square kilometers. And that too, the mining leases will not be automatically made.
So you admit that this is about mining. I thank you for that. See, I always had this doubt, but I would like to thank you for confirming my doubt and my suspicion that essentially the government, and I'm glad, I think Vaishali Rana, Shubhra Puri, Vimlendu and Bhavreen Kandhari, now the government through its official spokesperson of the BJP is being very candid. It is telling us that it is about mining. I only was suspicious earlier, but now Priyanka Kakkar and Satya Prakash Mishra of the JDU, it is now complete, Satya, it is now confirmed that this is about mining. So I would like to thank you for confirming my suspicions.
0.19%.
You have confirmed my suspicions, and I think this is a big victory for us. No, you can quote any statistic. You have just made it clear to me.
Why can't you debate on facts? Why can't you debate on facts? Out of 1.44 lakh square kilometers,
you will have to mute her for us to
speak. If only 0.19% will be available for mining, how does that rankle you? You don't want roads. You don't want bridges.
Only
I tell you one thing. I tell you one thing. One minute. Priyanka, I tell you.
And Priyanka Kakkar talking about environment protection is like Osama bin Laden talking about peace. इनके केजरीवाल सरकार ने क्या किया? What did Kejriwal do?
हमने ग्रीन कवर दिल्ली का बढ़ा दिया, हमने दिल्ली को ईवी कैपिटल बना दिया, आपने क्या किया? I don't want to make it a BJP versus RJP.
I'm hearing any time for a long time. I like to.
Did you deploy electric buses?
No, I would like to ask you. 1 minute, Sanju and Priyanka, may I please?
Deploy electric autos? No.
Okay, viewers, I say that 70% agree with me, 30% agree with the government, and 1 minute, please. Allow me, Priyanka. Priyanka, I'd like, just come in one. 80% of, see, ladies and gentlemen, I'm told I'm told, Arnab, you are criticizing the government. And I say, okay, I am supporting the people. And I think the people are supporting me. The public, Sanju, remember this always, the public is with Republic on this issue.
The public is with...
Public is with Republic on this issue.
Thing for the janta of this country.
You don't have an opposition, so you can't get away with doing what you want. अच्छा ठीक है, मेरा पूरा नाम आपको दोहरा के क्या फायदा हो रहा है? I'm saying my name is Arnab Goswami. Everybody.
सरकार के साथ है, इतना भूलिए, you are conducting selective outrage.
Currently, all the legislations are.
अच्छा, I ask you this on this. I'll ask you a straight question. No. 1 minute. I am told today that Sanju Verma believes the public is with the government on this. I am saying I am with the people on this. I don't think the people agree with you on this. And I can tell you, even your own political supporters largely don't agree with you on this. To varying degrees, people may say publicly or not. But I am glad, I repeat tonight, Satya, I am grateful to Sanju Verma for confirming my suspicion that this was about mining.
Is available for mining. You're forgetting 0.19%.
Currently, Supreme Court has clearly said no new mining license can be provided. Not only that, there has to be a clear, sustainable framework and management plan, and the government has come out with this definition. This should be challenged now. Supreme Court has not given a blanket permission to mine.
Satya, the Supreme Court also operates in an area where obviously public interest matters. See, you're a lawyer.
Do you know the full form of NPSM or not?
The question is on para 4.2.2, page 89 to 90 of the judge, the affidavit records, the affidavit filed by the Government of India records, as per the GSI, the Proterozoic Aravalli Delhi province constitutes an important metallogenic province of India. Hosting a wide range of mineral deposits and offering substantial potential for future exploration. The range contains, everybody on, well-known repositories of metals such as lead, zinc and copper, as well as precious and strategic minerals including gold and tungsten. So gold, sona, tungsten, copper, zinc, lead. This is about mining. This is about mining.
Now the Supreme Court...
No, 1 minute. It is, first of all, Shubhra Puri and Vaishali Rana. I made a point here, it's about mining. I think this should be candid admission by the government. It is about mining.
Right.
What do you think, Vaishali?
The government is actually talking about it, Arnab. Supreme
What do you
Court
think,
has not
Vaishali?
given any permission to give new licenses.
Right, Arnab. I'll start with your reporter reported from Charkhi Dadri, a site which we had talked about 3 months back, and we had submitted a representation at CEC stating the same, that mining is going on in Charkhi Dadri and licenses have been issued, but other than that, illegal mining is going on, and the representation was for that. It's been 3 months and there has been no action about that, and MOEF has not reacted on it. So this is just one specific, and today your reporter was at Charkhi Dadri, we shared the site with him, and he's reporting the illegal mining and blasting. There were about 15 blasts that happened that time when we were there. The videos have been shared with you. Other than that, in New Mewat, Honorable Minister came on live and he said that there is no mining happening in Delhi NCR. Well, Charkhi Dadri is Delhi NCR, and in New Mewat, one whole hillock has been mined, quarried and transported to Rajasthan, and another PIL is going on in Supreme Court regarding the same. And that is happening in New Mewat, which is Haryana. Delhi NCR again, it just continues to Rajasthan border. So then let's talk about Sariska. In Sariska's buffer zone, which is like 1 kilometer, where it is a no-go for mining. Mining is happening there also. That was also reported 10 months back, and they have not been able to check the illegal mining that is happening there. So I'm saying, what is sustainable mining here when the mining licenses have been...
That's precisely my point. Illegal mining will be curtailed. irregularity in mining operations.
You have given licenses for illegal mining. Illegal mining is happening where legal mining is happening. Illegal mining is being done by people who are doing got licenses for legal mining.
Why are you outraging when the government wants to control illegal mining?
May I just say what I have been making?
There will be no automatic clearances given to miners.
A representation was submitted in CEC. A report was submitted, a representation was submitted by...
Then you should be supporting the new definition that the government...
You didn't hear me. You didn't hear me what I said.
One minute, Vaishali is responding to you. Sanju, Vaishali is responding to you.
Illegal mining is happening at legal mining sites. It is being done by those same miners who have been given licenses for legal mining. They have violated every single environmental clearance that has been given to them. Pollution Control Board, MOEF, everybody CEC has failed to act on it. And we have given representation in CEC. How are you mixing up the two things?
Between Aravalli Range and Aravalli Hills, tell me the definition between the difference between Aravalli Range and Aravalli Hills. Do you even know the basics?
Sanju, I think Vaishali has done a lot of work.
Himalayas? Can you define Ganges? No, please do not complicate the matter. What I am saying, I am pointing out illegal mining happening in illegal mining sites. Please do not mince the words here. Please.
And curtailed. Why did you not wake up in 2006? Why did you not wake up in 2010? Why did you not wake up in 2012? Suddenly in 2025,
let's not. No.
Become a climate activist. You are politically motivated. That's my simple charge. You are politically motivated.
What is the simple charge? No, we are totally apolitical, ma'am. Please do not make it political for us. We do not align with any political party. On what basis are you saying it is political? Please do not put these allegations on us. All right? Please do some research work on our work and then talk about it. Do not say that.
This is not an allegation. You are politically motivated.
Yeah, you just said we are politically motivated. On what basis did you say I'm politically motivated? Do not make those statements about me without knowing what I do.
Seeks to curtail illegal mining.
Get the packaging ready.
So, how are you curtailing illegal mining? Please tell me how many officers have been suspended under whose charge illegal mining is happening in Aravallis. How many officers have been suspended for that? How many officers have been suspended
I would
for that?
like to now tell all our viewers that I'm happy to be joined by, we put him on air. It's a very important part. I am joined by Justice B.R. Gavay, who till recently has been Chief Justice of India.
Can you hear me?
I can hear you, Justice Gavay. Can you hear me? This is Arnab here.
Yeah, sure. Yeah.
Justice Gavay, I'm glad you've joined us because there's a nationwide debate on your judgment on the Aravalli case.
Right, yeah.
Can you hear me?
Yeah, I can hear you, yeah.
Okay. Ladies and gentlemen, it is my attempt always to go to the nub of the issue. Joining us is Justice B.R. Gavay, former Chief Justice of India and the author of this judgment on the Aravallis, which is being debated all over the country. Justice Gavay, I hope you will go through my questions and give me appropriate replies because fundamentally, and I would like to begin by saying this, Justice Gavay, that I have a fundamental disagreement with your judgment, which as a citizen of India, I'm entitled to have. The Aravallis stood for 2 billion years. The judgment that has redefined them was delivered 3 days before your retirement. What was the hurry, Justice Gavay? The judgment was delivered on 20th November and you retired on 23rd November. What was the tearing hurry?
See, I have been monitoring this issue for more than 3 years. If you go through the judgment, we had raised, firstly, see, judges are not supposed to justify their judgment, but since this is an important issue and there's a misconception about the judgment, I agreed to speak to you. If you go through the judgment entirely, the difficulty is that the persons speak about the judgment without even reading them in the entirety. So if you go through the entire judgment, I had given the entire narration as to how the matter arose. There was some issue with regard to the difference adopted by the various states with regard to definition of Aravalli hills and Aravalli ranges. So in order to settle those matters, we heard the matter on number of occasions. Various issues were framed, and after hearing the matter, once you hear the matter at length, if you don't decide the judgment, it's like
Justice Gavay, may I ask you, how can you pass that comment on me on my program that I have made my judgments on the issue without having gone through the judgment? I would politely, completely disagree with this presumption of yours and remind you that I have seen your judgment in entirety. In fact, no, I don't think you can pass a judgment like that, pass a comment like that on my observations, sir. I take offense to that. Having said that.
What I've seen on your program is that it is being projected as if we have given a complete license for mining in the Aravalli Hill, but that's not correct. If you go through the judgment, we have in fact imposed certain more restrictions on mining in the Aravalli Hills and ranges.
No, sir, your own judgment makes it clear on paragraph 30 that your final word went against the Amicus curiae, who is a friend of the court. Very explicitly, Justice Gavay, in paragraph 30 of your judgment, it notes that the Amicus curiae had stated in his submission, quote, if the definition as recommended by the committee is accepted, all the hills below the height of 100 meters would be opened up for mining, and as a result, the Aravalli hills and the ranges would lose their continuity and integrity. It would totally endanger the environment and ecology of the mountains.
So therefore, if you read the further parts of the judgment, we have considered the rival submissions of both the parties. We have accepted the report of the committee, which was consisting of various experts, various representatives of the state governments, and then we, on a surrender pattern, we have specifically directed that no further mining activities would be conducted.
Justice Gavay, in fact, in para 31, the arguments of the Additional Solicitor General have been documented. I've read that as contradicting what the Amicus curiae had said on the premise that, and I quote, it would exclude large areas from the Aravalli hills and ranges. She, however, submitted that if the definition as suggested by the committee is adopted, unquote. If the Amicus curiae, who is a friend of the court, has explicitly taken the view contrarian to the committee view, which has ministry at its helm, which has government at its helm, shouldn't the court have taken the view of the Amicus and not that of the government pioneered by the ASG?
Mr. Arnab, the court is required to take into consideration the submissions of both the sides. The court cannot accept. It's not necessary that always the court has to accept the submissions are made by one behalf. Maybe the learned Amicus is a friend of a court. The court has to consider all the aspects, and after considering the aspect, the court comes to an opinion. So it is not as if that we have to accept the arguments.
No, but the Amicus curiae, respected Mr. Justice Gavay, was going by the FSI criteria, but it said that the FSI criteria better preserve the ecological integrity of the Aravallis. Mike, with due respect to you, Justice Gavay, the FSI is comprised of India's topmost and most respected experts on matters of ecology and environment. Does that not matter to you? Are the experts less aware than the government? Or, for that matter, less aware than the judiciary?
Mr. Arnab, the FSI was also a part of the larger committee which was appointed by the court. The committee consisted of various experts from various fields, including the representative of the FSI. And the report which was submitted was not only by the government, it was a report of the experts.
Sir, I'm quoting from your judgment, para 27. The FSI had clearly defined the Aravallis in 2010 as, quote, under slope over 3 degrees, foothill buffer equal 100 meters, interhill distance or valley width equal 500 meters, and for the area enclosed by the above defined hills from all sides. What was the need to revisit this definition in the first place?
There was no question of...
Why did you have to revisit this definition in the first place?
So therefore, I made a submission that the comments are made without reading the judgment. If you go through the earlier parts of the judgment, the necessity was felt because all the 4 different states applied different yardstick insofar as the definition of Aravalli hills and definition of Aravalli ranges are concerned.
But that can't be a reason, sir. The
now
fact that the old definition...
Please,
sir. The fact is the old definition... The fact is the old definition recognizes slope, buffer, valley, enclosure and continuity, the very elements that make a mountain range a living ecological system, not a collection of isolated bumps. And yet, the court walked away from it. Why?
The court has not walked through it. On the contrary, if you read the operative paragraphs as well as the earlier paragraphs, we have specifically said that on a Saranda pattern, the MSAP has to be prepared wherein the mining which it will provide, which are the areas where the mining will be prohibited and where the sustainable mining would be permitted.
Sir, I would request you, Justice Gavay, there is a precautionary principle in law. The precautionary principle applies in this case, doesn't it? The precautionary principle in environmental cases means taking preventive action to protect the environment from serious or irreversible harm, even when there is no scientific evidence which is not fully conclusive. This means, as per precedent of the law, the onus is on precaution and safety. Why didn't you apply? I would like to ask you, you have been the Chief Justice of India. The nation wants to know from you, you've been Chief Justice of India in this case, why did you not apply the precautionary principle in this case? There have been innumerable precedents of precautionary principles being applied by the honorable courts on matters of environment. I don't find those quoted in your judgment. May I ask you why?
If you read the operative part, it is very much clear that unless the MSAP is finalized by the IFTRI and finalized by the MOEF, no further mining licenses would be
Justice Gavay, Well-Lord Citizens Welfare Forum versus Union of India, 1996. The Supreme Court declared the precautionary principle a legally enforceable principle crucial for sustainable development and shifted the onus of proof onto polluters. MC Mehta versus Union of India, Taj Trapezium case, 1986. The Supreme Court used the precautionary principle to stop industries from burning coal near the Taj Mahal, recognizing harm from pollution. I am not an advocate, but I'm asking the former Chief Justice of India, a matter of principle, why did Justice Gavay not apply? Why did the three-judge bench not apply the precautionary principle in this case?
If you kindly go through the operative part, clause 4 and 5 make it very much clear that unless the MSAP is finalized by IFTRI and MOEF, no further mining leases will be granted in all 4 states in the Aravalli.
Sir, the precautionary principle means that in matters that are likely to affect the environment, it is not required to prove that the activity will cause harm, but that the activity is prohibited unless it can be established that it is benign. No one is suggesting here that deforesting the Aravallis will... Sir?
What does the prohibition on the new mining licenses amount to?
Okay, sir, then let me ask you the AP Pollution Control Board versus MV Naidu case 1990 to 2000. Landmark Indian Supreme Court judgment that reinforced the precautionary principle, established the right to clean water as a part of the right to life, Article 21, and placed the burden of proof on polluters. All these cases were there for you to look at, sir.
We have looked at the cases, and this is T.N. Godavaram and N.C. Mehta are the continuing mandamus proceedings. They are not as if we have closed the matters.
What do you mean?
The
it's not as a... Sir, I'm asking... So you're saying the matter is not closed?
Matter is not closed. We have directed the MSAP to get the report. The MSAP report will come to the Supreme Court. Supreme Court will find out wherein the mining activities are to be permitted and where they are to be prohibited. It is not as if that the matter is closed.
Sir, but you've not looked at other cases which were in the public domain. There is a May report by the government. It's titled Detailed Action Plan Aravalli Landscape Restoration, in brackets Aravalli Greenwall. The irony is this report was published by the Ministry of Environment and Forests. It's not even an old report. It was published in May 25, just 8 months before the Supreme Court redefined the Aravallis. It involved the Forest Survey of India, state forest departments of Delhi, Gujarat, Haryana, Rajasthan, along with German Cooperation for International Cooperation. Now, this report was in the public domain and the nation wants to know from you, Justice Gavay, as the former Chief Justice of India, would you see it the other way, that this report had very much established the threat to the Aravallis? 8 months before your judgment, your new definition allows for leeway by the mining players to exploit an already depleting resource.
Mr. Arnab Goswami, it is firstly not the definition provided by the court. It is a report of the committee of the experts the court found that the report was liable to be accepted subject to the further requirement regarding, I am again repeating it, we are again going to the same
So you don't
question.
completely agree with the government's version, which the government says we are only going by what the Supreme Court says. You are saying you're only going by what the government told.
We are going by what the report of the experts, of which the FS was also a party. We only accepted that, and in addition to acceptance, we imposed certain stringent conditions which would protect the mining activities. Unless the MSCP is finalized, no further mining will be permitted.
Sir, you've seen Sir, you've seen the report.
If you kindly go through paragraph 4 and paragraph 5 of the operative order, it is more than clear.
Sir, you have seen the affidavit out here, sir, of the government which was filed in this case, because I've gone through it in detail. It's 2000. You say I have not seen the reports, but I have read every word of the 2,334-page additional affidavit filed by the Ministry of Environment. Sir, I am very detailed in my work. Sir, the fact of the matter is the government is trying to institutionalize mining as a core objective, not as an exception, by formally designing a framework whose purpose is to enable exploitation, mining inside the Aravallis.
No, but then we have not accepted that. We have specifically stated that unless and until MSAP, the management of sustainable development plan, is finalized, no further mining leases.
Sir, may I ask you a question, sir? You also said, sir, now that there is considerable public outrage on this matter, and by informed people, not uninformed people, do you believe that if necessary, this matter should be looked at again, reviewed, discussed?
I have always stated that the law has to be static, law has to be developing, law has to be organic.
Yes.
We have, on various occasions, wherever we have found that earlier orders are not correct, the courts have always corrected them. So therefore, I was not inclined to speak to you because the matter may come in review, and normally the author of the judgment should not speak about the judgment. But since you insisted that this is an important issue pertaining to environment,
yes.
So if the subsequent benches find that something more to be done, it is always permissible. So the TN of Godavarna is the continuous madness process.
So it can come up for review. I mean, your view is given. I'm sure you've kept track of the public discussion on this matter, sir, over the last few days, and the amount of attention it has got.
If the court subsequently finds that something more needs to be done, something needs to be corrected, the courts can always do it.
And the government should be open to review as well, given all the expert opinion, others, it can be put through review again, this decision, this definition, in public interest?
So I can't comment on what the subsequent, because I am now I can't be a part of the bench now, I am out of the system. Wherever the matter is brought before the bench will always take into consideration all the aspects.
Sir, is the Supreme Court adjudicating mineral potential or environmental protection?
It is considering environment protection, and if you go through the various orders which preceded this order is not passed in a day. It is passed over an exercise which was undertaken for last more than 1.5 years, insofar as Aravallis is concerned.
So the government is portraying this as a Supreme Court mandated environment protection, as an economic loss, building a grievance narrative to reopen mining on revenue. My point is, sir, you are the author of this report. I have read every word of the report. Of the judgment. I believe there needs to be some balance between the views of the government and the concerns of the citizens.
I have always been advocating the concept of protection of environment, protection of ecology, and the sustainable development. So wherever there is a conflict, a balance has to be given. The environment has to be protected. Ecology has to be protected. I must have authored around 18 to 20 judgments in last 3 years for the protection of environment. And the courts are always, it is always permissible for the court if there is something more to be done, something to be corrected. The courts are always open to it.
Sir, matters are taken suo motu by the courts.
Yes, sir. TN Godavarna is a suo motu. MC Mehta is a suo motu. MC Mehta is on a postcard of...
but this was a suo motu as well.
This was not a suo motu. If you go through it, the concerns were raised by the various states that there is no consistency insofar as the definition of Aravalli hills and ranges is concerned. And therefore, in order to bring a common, uniform definition, the court was required to go into all these issues.
So what stops anyone from redefining? Sir, tomorrow somebody will define the Ganges. Tomorrow somebody will redefine the Himalayas. I said the other day with respect that the Supreme Court of India did not create the Himalayas or the Aravallis.
I have already told you it was necessary in order to protect the illegal mining activities which were going on. The various states were saying that it is not in the area doesn't fall in Aravalli hills and therefore the mining can go on. In order to avoid all that, we were required to pass those directions.
So I think that, okay, so here's the point. Now, in this particular case, Justice Gavay, the nation is angry. 80% of the people feel there should be a revisiting of the judgment. Are you, what is your view on the need to, on revisiting the judgment? Because the government is taking a very stern, inflexible position. You're the author of the judgment.
I can't make any comment on that because any comment by me may be prejudging the issue because I am out of the system. I don't want to make any statement which may have a direct, indirect effect on the proceedings that may arise in the court. And that is why I was reluctant to speak because the judges before whom if the review is filed are always entitled to take a relook at the matter and take appropriate action. I can't make any comment.
Well, I appreciate your coming on air tonight because I got a chance to put some straight questions. I hope you will also say, sir, today that after this interview, you would not say that I have not read the judgment, and I hope you find the merit in the questions that I have phrased before you. Because I believe Justice Gavay that the judiciary is important, the media is also important. It's important for us to get the opportunity for this interaction.
I have due respect for the media, but I again say that you have not read the judgment completely. If you had read the judgment, the first 2 or 3 paragraphs, you would have come to know as to why this entire exercise was necessary.
Sir, I again tell you I have read every word of the judgment from the first to the last page.
I'm sorry.
And I have not just read this judgment, I have read previous judgments on the matter, and I politely disagree with your interpretation to it. I hope you feel that I have a right to do
We are not here to convince each other. We are not here to convince each other.
No, I'm not trying to convince you. I'm just taking your view.
Hold that had you read the judgment, you would know as to why the requirement for having the definition was required.
Sir, I have read the judgment entirely. Otherwise, how could I quote para, chapter and verse to you right now on the judgment?
Then if you have read the judgment, it is the learned Amicus who requested the court to take steps to define the judgment, define the definition of Aravalli hills and Aravalli ranges.
Well, I mean, everybody is shooting off the other shoulder, sir.
So anyway, thank you very much.
Yeah. Well, thank you very much, Justice Gavay, and thank you for coming on Republic. Thank you. Ladies and gentlemen, that's Chief Justice of India, former Chief Justice of India till a few days back. Justice Gavay, is the panel still there, please? It wouldn't be fair to close. We've had an interesting exchange there, haven't we? Ladies and gentlemen, it's not every day that the former Chief Justice of India comes on, and I appreciate the fact that he came on his judgment. And we got a chance to ask him the questions. Not convinced here tonight. How do you think that went? I'd like to ask those watching the program tonight. I'll open up for calls. Ladies and gentlemen, remember this issue of the Aravallis is an ongoing issue. It's a hot issue. The headline for me there, if you ask me, the headline for me there, Bhavreen, is the fact that the author of the judgment says it's okay to revisit the judgment. There is nothing. It's fluid. And that's what my biggest takeaway is from this. What do you think, Shubhra?
Yeah, Arnab, see, we've heard we've heard the government representative today. We've heard the judicial Justice Gavay also. Now, there's been so much ruckus, there's been so much of nervousness on part of the citizens regarding the definition of Aravallis. I think the government should use this opportunity to clarify. All we are asking as citizens is to clarify and bring transparency into the statements so that, we don't hear contradictory, convolutory statements and there is uncertainty about what is the definition of Aravallis. If, for example, the government has said that there are 39 districts, the Environment Minister has gone on record to say that Aravallis is across 39 districts. Can we know what are the number of hills in these 39 districts which are protected, number of hills which are not protected. Can we have clarity? Can the government issue clarity? If this judgment was in the best interest of people and the citizens, and if it was actually against illegal mining, as Justice Gavay said, we need clarifications. Can you just give us clarifications on what is the Aravalli
definition is? The new definition is Vaishali against illegal mining. The new definition is more scientific. The new definition does not allow.
No, ma'am, but this is not the definition.
The new definition does not allow automatic mining.
You have to tell us what is the
definition does not allow automatic mining.
You're again
The
evading
new
the
definition does not allow automatic mining to minors. And I want to ask you one thing. You know, I heard you, I've seen you on YouTube. You keep saying the government has not clarified what exactly is it when it says land forms above a height of 100 meters. It is land form above height of 100 meters compared to surrounding flora and fauna and all
Ma'am, I heard, excuse me, but the Environment Minister now talks about 100 meters, not at the base level, but 100 meters from below the ground.
Aravalli definition by the Modi government is against illegal mining. Do you support illegal mining? Do you support illegal mining? No? Then please support me. Please support the Modi government. Please support the
What was the need to revisit this definition?
Priyanka is also on the debate right now. I'm closing in 30 seconds.
Ma'am,
let me tell you what the courts held against the state of Haryana. Unfortunately, the town and country planning department of state of Haryana has been supporting the illegality.
Ladies and gentlemen, this is I'm getting a lot of calls tonight. I'm getting a lot of calls tonight, and people are saying tonight that Arnab, that was a rare television moment. That was a rare television moment when you interviewed and grilled the former Chief Justice of India. I would say this should become normal in Indian democracy. The highest of public functionaries in this country should open themselves up for questioning. Only then will be a true democracy. That interview, that questioning of former Chief Justice of India, Justice B.R. Gavay, is going to be played in a few minutes. This is an unmissable exclusive. Thank you very much for your support to Republic on all these occasions. Don't miss the interview that's coming up.
Time for a quick breather.
ये है सीक्रेट रेसिपी MDH का जीरा सब जलजीरा मसाला।